Okay, well, welcome to this final session, for which we have Andy Sabl from Sabl. Sorry, most important. From UCLA, but currently at Princeton, and next year going to be at Yale. So there is the Yale UCL link continues, and he's going to be discussing chapter 7, I think, claiming rights across borders. So we'll have, as per usual, 15 minutes from Andy, response from Seyla, and then open to the wider world.
Okay, well, thank you. This late in the afternoon, I guess I should congratulate Seyla once again for her stamina, and all of you for your patience and staying. Being the last person, I find that some of my remarks have actually been covered in other people, so you may have seen me editing some of what I had to say so far. I think I still have some points left, and I've expanded on some of them, and in particular, I think I might have more to say about some of the directly political implications of the work, and especially the kinds of questions that Raymond Goyce has urged us to focus on as distinctly political, namely the old Lenin question of whom, putting some proper names and not just reasons into the discussion. So in this chapter, Claiming Rights Across Borders, International Human Rights and Democratic Sovereignty, Seyla addresses a variety of worries about the increasing influence of what she calls transnational legal norms, in particular those regarding human rights. She discusses, as she mentioned in some of her introductory comments, a variety of perspectives that have given rise to such worries about transnational norms. A fairly old-fashioned, quasi-ethnic form of nationalism opposes international human rights norms for fairly obvious reasons. But one can also worry about such norms from a more Rousseauian perspective involving democratic sovereignty, whereby laws can only be truly legitimate if they result from a process where a self-determining people can regard itself as both author and subject of the laws. Finally, Seyla mentions those who regard international human rights laws as imperialist or neo-colonialist. Now, she responds by denying that international human rights claims either typically do or should involve a demand that countries simply adopt a uniform set of detailed rights as standard and binding law within their national borders, as identical to the laws adopted in other countries. Now, she's spoken about this in her introductory remarks, so I will skim past what I was going to say about how generativity underpins rights claims by activists and civil society groups working within democratic polities. Now, this generativity has implications for both the agents of human rights law and its content. Regarding the agents, Seyla criticizes any possible reliance on judges and legal experts as the exclusive arbiters or originators of human rights, though of course they play an important role. She prefers to focus instead on the use of human rights norms by social movements. She argues that international human rights norms can empower citizens and democracies by creating new vocabularies for claim making, as well as opening new channels of mobilization for civil society actors who then become part of transnational networks of rights activism. On the level of substance, human rights norms require local contextualization, interpretation, and vernacularization by self-governing peoples. Appreciating the process by which this occurs will, in Seyla's view, reveal that it's mistaken to regard such norms as imposed from above or outside a given polity. Disposing rather quickly of critics who are nostalgic for the absolute legal integrity of national territories in the face of international claims, as well as of quasi-ethnic defenders of the traditional nation-state, Seyla focuses on the two objections that she takes more seriously. The democratic objection derives, as said, from the ideal of a self-determining people that is subject to its own laws. While skeptical of particularly uncompromising versions of democratic sovereignty, such as the kind that Thomas Nagel has appealed to in order to reject out of hand any proposals for global justice, Seyla thinks we should take milder versions of the democratic sovereignty argument very seriously. as reflecting a reasonable worry about a politics of global legal experts and technocrats, given the results of such expertise with which we are all too familiar in the economic realm. As for the anti-imperialist or anti-neocolonialist critique, Seyla makes fairly short work, again, of the worry that human rights claims serve global capital, pointing out that many human rights norms would, if implemented, distinctly hinder unrestricted capitalism. She mentions the right of workers to organize, the right to healthcare and welfare provision, and so on. She's much more sympathetic to the fear that unlimited responsibility or duty to protect could be used to license unlimited and escalating military interventions on the grounds of alleged humanitarian concerns. Though here I would register a bit of bafflement about how the worry has been put forth, given that the most famous and large-scale recent example of military intervention by great power was carried out with an extraordinarily different justification by an administration that explicitly held international law in contempt and did all it could to sabotage the International Criminal Court. Perhaps around here, Tony Blair's talk on the subject would have had a somewhat different flavor, one that stressed human rights somewhat more. Here, David Runciman's book, The Politics of Good Intentions, might show some of the dangers of such talk, and I would admit that. I would point out as well that this chapter does not explicitly address the worry regarding humanitarian intervention, though it mentions it at the beginning. The categories that this chapter employs in practices seems most relevant to the question of how democratic governments implement norms of equality within their own borders, and more on this later. Now, against the democratic sovereignty worry, the one that most centrally concerns her, Seyla argues that broad concepts of human rights can be translated into specific conceptions of appropriate human rights law in different ways in different countries, respecting local debates about which conceptions are appropriate, given national traditions and local circumstances. This was mentioned earlier today, but I'd like to mention a bit more detail here. So equality before the law is regarded with a substantial degree of multicultural differentiation in Canada and India, but not in France or the United States. And the idea of parity in gender relations motivates a 50-50 requirement for party election lists in France. It has more effect on university athletic teams in the United States. These variations are justifiable, in fact desirable, precisely on the grounds of self-government, and Seyla has talked about the reasons for that before. Given the right to self-government, we can not only justify this range of application, but celebrate it. So, I mean, this actually matters a lot, right? So does equality require multiculturalism or its opposite? And Seyla's answer is no. Given the right to self-government, we can not only justify this range, but celebrate it through processes of arguing through the meaning of rights within each polity, through civil society as well as formal governing institutions. We can instantiate human rights in ways that address worries regarding democratic sovereignty and Western parochialism. In fact, human rights norms thus employed enrich and enhance democracies by providing them with new vocabularies. Seyla's main example involves the ways in which women's rights activists who identify with a Muslim perspective, rather than denying it, have productively and creatively acted to different effect and with differing and culturally sensitive rhetorics in a variety of countries that have either Muslim majorities or substantial Muslim minorities that have given rise to calls for special family law systems that allegedly track Muslim commitments and values. In Canada, such activism resulted in a resolution that Seyla seems to applaud, whereby Muslim family courts were adopted, but their judgments were rendered strictly advisory rather than binding on those who rejected them. In sum, and with reference to Kant via Habermas, Seyla writes, without the basic rights of the person, Republican sovereignty would be blind. Without the exercise of collective autonomy, rights of the person would be empty. Now, my immediate reaction to this argument is almost completely favorable, which is surprising given how little I have in common philosophically with Seyla. I greatly applaud the pluralism of the constitutionalism involved. Pluralism in two senses: its openness to differences in how rights will be institutionalized in different countries, and to a plurality of actors, none of which has unique authority over these questions. I applaud the insistence that human rights claims are not above or apart from politics, but work most effectively as well as most justly and made part of politics, given that the authority of governments, as well as the specification and limitation of that authority through rights, are constituted by public opinion. In fact, I think this chapter's argument is robust in the face of disagreement regarding the foundational claims that Seyla makes elsewhere in the book, and of course in the body of her work as a whole. In order to endorse its picture of productive norm diffusion across national boundaries and in interaction with a variety of democratic polities, one need not in fact believe that human rights are based on the moral principle of the communicative freedom of the person. So I don't think Seyla would like this amendment. It is intended as friendly. For instance, I think that the argument of the chapter is very much compatible with and could be brought in very productive dialogue with the claims of the so-called English School of International Relations. Have in mind the English School's insistence that the so-called realism of dogmatic international relations scholars is anything but real, that its stylized Westphalian model of discrete and sovereign states interacting with one another on the basis of power and interest alone doesn't respect the phenomena that states in fact face each other and have for a long time, faced each other and their own citizens within a rich framework of, loosely speaking, Grotian norms governing their appropriate behavior, norms that for the most part lie between national self-interest on the one hand and a uniform demand for altruism and cosmopolitan universalism on the other. I do think more could be said on a few points. First, as noted, I think the chapter more successfully answers some of the worries than others. To the extent that human rights arguments might be used to justify rampant military intervention, either subjectively sincere intervention or intervention that uses rights as a cover for other motives or interests, I'm not sure that this chapter provides a remedy. It seems best suited to explaining and justifying how relatively open societies implement human rights claims within their borders through at least approximately democratic processes of self-government, not how states with powerful militaries seek or do not seek to protect foreign people's cruder claims to life and liberty against rulers whose rule they assert to be undemocratic and tyrannical in the first place. If the goal is to prevent human rights talk from justifying militarism, it seems to be that the work to be done will not be that of civil society activists implementing human rights norms within a polity, but partly international in scope to prevent poorly specified duties to protect from being promulgated by bodies such as the UN, and partly oppositional in that those who stress the humanitarian costs of intervention will find themselves sometimes in the position of participants in self-government, but often the old-fashioned and less Rousseauian position of dissenters, who stand as minorities of a democratic public, in opposition to a consensus that may be forged by powerful military and political elites, but successfully forged and all too popular. Second, while I applaud the triumph of rights in conjunction with democracy as powerfully described in this chapter, it seems to me that the success of this synthesis has a possible dark side or negative aspect to it. That is that we might analogously see the international propagation of norms other than those of human rights on a similar model of democratic iteration. I have in mind conservative, one could probably accurately say reactionary, religious norms, which sometimes people focus on a Muslim threat, but by no means is that an exclusive threat. In Africa and America, these norms or attempted norms are very often Christian. And I think this could be the dark side of Cecile's idea of deterritorialized religion. So these conservative or reactionary, but I think genuinely cosmopolitan movements demand internationally, or in any country that will take them, restriction of the rights of gays and lesbians, sometimes their active persecution, the return of women to allegedly traditional household roles, and especially in some Christian cases, restrictions on contraception and sex education. Now, consider in this regard the intervention of fundamentalists in the United States and Uganda. They've been losing in the United States in their attempts to preserve or extend anti-gay legislation, but in Uganda they found a much more receptive locality. They were able to use their status as representatives of an advanced and wealthy and culturally perceived as important country to put a stamp on what local anti-gay activists in Uganda wanted. It initially resulted in the adoption of a law that would have given the death penalty to homosexual activity. Now, there was democratic iteration around this. There was protest, there was calls to reconsider the law in different political bodies, and in the end, the law was in fact modified as a result of these processes. It no longer includes the death penalty, though it does include various penalties for promoting homosexuality that could be used to jail all sorts of people. Now, I think that that Seyla's discussion may claim democratic hope, but I think democratic hope is consistent with pessimism, but I think she often slips perhaps into a kind of optimism, a subtle optimism that good discourses will win out and that bad ones will eventually lose out under these processes. And I'm wondering how we can be so sure. I worry about jurispathy, I suppose, or about what might be called bad democratic iteration, like that famous article, Bad Civil Society. And the Schklerian pessimist in me wonders how one can be sure that this propagation of international norms will proceed in a progressive direction rather than the opposite. Finally, I suspect that the propagation of human rights norms will, perhaps should, be easier in some kinds of cases than in others. In particular, I think it's no accident that most of the vivid and convincing examples in this chapter involve what might be called bright line cases of human rights. That is, the presence or absence of those rights in the case of life and liberty, the presence or absence of a 50-50 division in the case of gender equality, of binding or non-binding rules in the case of marriage courts. These are things in which one can easily rally to one side or the other and know where the sides will line up. When Seyla mentions the International Declaration of Human Rights provisions of social and economic rights as possible sources of resistance to global capital, I wonder whether they in fact commonly play that role. It's my surface impression, though I'm certainly willing to be corrected, that demands for a welfare state, for economic opportunity, for healthcare provision, and so on, typically, when successful, use national and local languages of solidarity, security, and looking after one's own, rather than the language of international human rights. And here I think I very much agree with Richard's concerns. And the reason for this tracks, I think, the reason why John Rawls considered his principles governing legal and political rights a more suitable object for civil disobedience than the difference principle was. Namely, that questions of social and economic equality were too technically difficult and too dependent on contingent political judgments to provide clear and clearly justifiable rallying points for social movements and resistance. That bright lines make for better rallying points than questions of more and less is likewise a claim common in other traditions, for instance, some rational choice literature. Now, this claim that bright lines are persuasive in the political and legal realm, but more elusive in economics, is no doubt too sweeping, and I can already think of some exceptions. But in any case, the question of when international human rights norms will be jurisgenerative, will in fact produce new vocabularies for justice that prove useful and convincing in a given country, seems to me a contingent question regarding the success or failure of certain rhetorics in certain contexts. It seems to me, if I dare say so in front of this audience, an empirical question. The fertile claims of this chapter therefore seem to me a proper subject not only for normative argument, but are also for serious work in sociology, political science, and history. At issue are the facts of our politics as well as their norms. Thank you.
Thanks, Andy, for these very thoughtful and comprehensive comments. I guess it's a good way also to sort of conclude our discussion. I want to stress again wide areas of agreement, but I want to come back to your claim that in fact somehow I seem to present this model of democratic iterations or jurisgenerativity in a somewhat unilinear or a teleological direction. I mean, basically, the claim about a jurispathy. I want to claim not guilty to that. I mean, there is the question about the bright line cases, and we should discuss that, and socioeconomic rights in particular is a very important issue that I want to come back to. But no, I think that there is nothing in the logic of democratic iterations that says they always result in juris generativity, and that's why we had the discussion in the morning about the relationship of norms of practical discourse to democratic iterations. And this permits me, to come to the examples that you gave of the spread of religious norms, evangelical movements, Jehovah's Witnesses, but more than that. And let me just, play this thing out. The Uganda example that you gave of anti-gay legislation, the propagation of norm, but these are total and complete cases that fly in the face of practical discourses. They are not examples of democratic iterations for me because they are exclusionary, they do not permit reflexivity, and they are, agenda closing. So if, it really takes us back to the discussion of this morning, and maybe somehow, I'm not fitting the pieces of the puzzle together very well. I'm willing to accept that. But, in my defense, I will say, look, there are concepts, I don't think that we would disagree about. There are concepts like legitimacy. Since Max Weber, we know that this concept has both an empirical and a normative purchase. And when it came to the normative purchase, Weber gave us 3 theories, 3 models: charismatic, traditional, religious, legal, rational. Now, in my case, the question of democratic iterations has both empirical and normative purchase, but the normative purchase, unlike, Weber's, which was much more descriptive, permits me to precisely say, no, these are not cases of democratic iterations. They cannot produce of juris generativity precisely because they violate these formal criteria. So, as I say, the fault may be mine in not, linking these together, but I would plead that that is really not an appropriate example in this case. Now, the question of socioeconomic rights, that's really, and throughout the book, I don't say anything about socioeconomic. I don't say much about socioeconomic justice. I just, what would a cosmopolitan theory of distributive justice be? I'm very sympathetic to, our colleague Thomas Pogge's efforts, but I haven't really worked on those. But what is the relationship between socioeconomic justice claims and rights claims? Human rights claims. Pogge has this expanded conception of cosmopolitanism where he actually thinks, I think he's reading Article 2022 of the UDHR that guarantees to all human beings an order compatible with the rights listed in this document, and he's reading this as creating obligations on states of a rather radical kind to engage in creating that kind of an order that is also compatible with socioeconomic rights. I don't know if that would be the way I want to go. I'll have to just say that it seemed to me to be equally important as the global distributive justice argument to focus on more core, also civil and political rights, about which we assume so much agreement, but we don't really know what the agreement is about. So I plead with you, yes, that there's, but there was one way in which, and you return to this, the question of global capitalism, human rights, and socioeconomic rights. The end of the chapter, and this is very important for me, begins to point out to the ways in which global capitalism has also generated growth zones and basically zones beyond the law. There is, as you call for it, there's quite a bit of good sociological study on this. Aiwa Ang, a South Asian sociologist, anthropologist, she has done brilliant work on how countries like Singapore, Malaysia, and sometimes Indonesia, they have created these basically special growth zones where rights of collective bargaining, but also many, human rights of immigrants, including being able to have, their passport at their own possession and so on, are suspended. These growth zones that are based on concessions that national governments and our transnational coalitions make to global capitalist firms, this is huge. This is huge. And these are actually not enabled by human rights norms, quite to the contrary. These are fundamental violations of any kind of human rights claim. I mean, there is enough evidence to show that in the case, for example, of female migrant workers, as opposed to factory workers, which were their passports are taken away. They are subjected to periodic sexual tests for pregnancy, and they have no vacation rights of any kind. I mean, there are forms of emergent, what are being called domestic female servitude within these contexts that are, and some things like this are also going on all over the Gulf countries, by the way. Yeah, with very large numbers of women, poor women coming from Asian countries or Sri Lanka as domestic servants. And in particular, the question of unionization rights, collective rights. So all I'm saying here is that I agree with you completely. Much more work needs to be done on this. I just wanted to sort of drive a wedge into the debate that was beginning to take place in the, particularly in the US. I wanted to drive a wedge and say, also think about the ways in which cosmopolitan human rights norms at their core and global capitalism are antagonistic to one another, because it isn't just simply the right to free markets and the right to free property. I don't think there is disagreement between us about this. I will be the first to concede that much more empirical study needs to be done on understanding how this is going along. And my final comment is this about humanitarian interventions and the question of what is to be done to whom. This book, it's it was written at a particular moment. And you are absolutely right that in the case of the United States, the justification for the war in Iraq was the spurious claim of weapons of mass defense, and this was what was put forward. It was only when Tony Blair came to George Bush's aid and presented this as a case of humanitarian, engagement against a tyrant. And we did see those initial scenes of Saddam Hussein's statue being, sort of thrown down by the cheering masses, that somehow the idea that there could also be humanitarian intervention dimension politically came out. But then, this whole debate morphed into the R2P, the responsibility to protect over the years. And if you know, a good example to trace the political climate of this is someone like Michael Ignatieff, right? Michael Ignatieff begins with the support of the Iraq war. As the years progress, he begins to get more worries about human rights language, and the last thing that he does is on American exceptionalism and American exemptionalism. I agree with you that I gesture to this context, but I do not fully explore, the deeper questions of when, how, when, and what is to be done.
Very, very briefly, I do think there's lots of agreement, but I would like to press a little bit on the question. You say that there are formal requirements for a democratic iteration, and it's precisely the formal requirements that I think were met. So there's it wasn't agenda closing. You could reevaluate the law at any time. There was reevaluation during the
exactly though. What are we referring to? I'm sorry.
I'm sorry, the Ugandan case. Right? So the law could be reevaluated at any time. There was there's democratic legislature. There's a long debate. There was opposition expressed. It seems to me that one shouldn't assert that there's formal violations when what one really means is substantive violations. It was the content of what was debated and resolved that was loathsome. I'm not sure that the formal conditions were violated in any way. And that's why I'm wondering whether the formal conditions can do the work that they're supposed to.
By the formal conditions, I do not mean simply the conditions of legal parliamentary debate, though sometimes, of course, they are involved as well. But I mean, this is just like the simplest. We know this from apartheid, and Hitler's decision to deny citizenship to the Jews was legal as well. The criteria of practical discourse are not legal criteria, though they have legal implications. They are, more substantive, ethical criteria. So we have to assume, I guess, that had gay groups had a say in this, a voice in this, as practical discourse would require of you, that they would accept a legislation that would ban their actions to be illegal. Is that what we would assume? I mean,
well, I wonder what you mean by having a voice. I mean, being listened to and successful. If you say that, of course, it's true, but it might be circular. I mean, if you mean being allowed to express oneself. I mean, so again, I wonder whether there's something, there's this substantive opposition as a result that ends up coming in under the name of a formal reform.
No, I see what you're saying. I mean, this is an important point, but. Having a voice here presumably means exactly what Rainer Forst says it means, that you cannot be overruled by the majority. You need to have a veto power in something as substantial, in something as fundamental as what concerns your voting rights. I know this is a bit of an extreme. But I don't quite know that this case really is a successful counter example. I mean, I have to understand if your argument is that given this criteria that we have to think of a situation of discourse, not just a majority vote. When a group that is being excluded from the discourse, that is being disenfranchised, or whose substantial interests are being affected, we're not talking about gay, the hair color. We're talking about, something that is substantial. Whether in effect we are to construct the practical discourse in such a way that yes, that would also result. And all I'm trying to say is that these formal criteria would at least minimally exclude certain outcomes. It would not exclude other outcomes. I know you're not convinced.
I'm sure we can throw it open for discussion.
Yeah. Eric.
I can go to follow precisely at this point, which seems to me that perhaps in your work since the right to have rights has been a bit at the center of the questioning. That is precisely what is the specific nature of democratic interaction. In a sense, also from this conversation just now, it would seem to me that there is a kind of circularity between what you consider to be democratic interaction and their capacity to produce certain kind of a right regime, or the juris, the jurisprudential kind of ability of politics to produce a new order. So democratic interaction are those kind of intervention from politics, from movement, from democratic debate, and so on and so forth, which produce a kind of new juridical regime which in some way is able to establish itself. And therefore the ultimate test become a substantive test of being acceptable, but also in some way of being, you know, I agree with you that your position is not teleological, but it seems then eventually to, because it's optimistic, it seems to be read in that way. So I wonder whether, are there other ways in which you can describe what we can take as democratic interactions?
Iterations, you mean?
Iterations that in some way have got a kind of democratic quality itself, or because you bring in a number of political activities of different sorts, which we don't normally describe specifically as democratic, in some way their test come from what, you know, what their outcome is.
Let me just correct you in one thing, that I am not saying that URIs generativity establish a new jurisprudential regime. No. URIs generativity is about a particular kind of interpretation, iteration, and contextualization that expands the circle of addressees of the original norm in a way that may not have been intended by the norm itself. All equality norms seem to me to have this logic. They're not meant for, you know, gay and lesbians to adopt children. They are not meant, you know, for young women with a foulard. But when these agents claim these norms for themselves, URIs generativity in the sense of the expansion of the agents making those claims and the language of public norm articulation changes. So it's a very specific thing. Now, I don't know if you're thinking of Frank Michelman. Frank Michelman really uses the term URIs generativity in his early work in terms of the fundamental process of a polity giving laws, you know, to itself. And I like, you know, Michelman's work, but I wasn't talking here about that moment. I was thinking more about a kind of ordinary process of democratic, you know, iteration. I mean, having said this, I think that the irritation that some of you are feeling, I mean, you know, most people, you know, like this, is that what relationship does it bear to the, you know, ordinary dirty business, you know, of democratic politics, which so often seems to be about compromise, horse trading, corruption, negotiation, and so on. And I'm going to plead guilty to one thing, and it's not optimism and, you know, pessimism. It's about the logic of theory. Okay. I am also writing as a theorist of democratic hope. Yes, democratic pessimism is necessary, but as you know, I knew Judith Schklar very well. She was also my mentor, but this is a different kind of context. So I'm writing from the perspective of what is possible and where also there are glimmers for sort of, you know, moving the normative universe towards, you know, or the arc of the normative universe always bends towards justice but does not reach it, right? I mean, you know, George Cohen's title, but it's a phrase from Martin Luther King, if I know correctly. So that's why, you know, I think the terms optimism, pessimism do not quite apply to me. Look, I mean, political philosophy is a very deeply personal thing. We're not doing astronomy, we're not doing chemistry, we're not doing genetic research, which may also be deeply personal. In some very deep way, these are about existential commitments, about, you know, who we are in the world. And of course, with someone like, you know, Judith Clark, she writes this beautiful autobiographical essay that explains why for her avoiding cruelty, escaping cruelty, is the principal value of liberal institutions. I have a more maximalist expectation of, from democratic institutions that very much really comes maybe, this kind of odd mixture that I have always had of Habermasian discourse ethics and a kind of American neo-Hegelian pragmatism of my friends like, Richard Bernstein and Nancy Fraser, right? And it is a little bit, I think, that this notion of democratic iterations is reflective of this broader project of understanding democracy, as Dewey said, the application of collective intelligence to the solution of common problems. Which you may say, well, it's too diffuse, etc. No, but it's also saying something. It's also saying something that we need, at times when that is lacking. So maybe, that is the, so I bristle a little bit at the term optimism, because I think that it is really, more a kind of commitment. But, having said this, one also needs to see the darker side. I mean, if I'm completely negligent of the darker side, then what you're saying is a morning prayer. You're not doing political philosophy. I sincerely hope that that's not the case, but,
Can I?
Please. I don't want this to be the last word.
Well, maybe I'll ask a question to answer. So, I mean, in part, this is a clarificatory question. So, you make a distinction between international and transnational law and rights claims. And I wanted to see if I'd understood this distinction. So, an international rights claim, I interpret it as meaning, is the right to have rights in place? So that that's a kind of universal thing which applies to all political units, if you like. And so that's like what basically the European Court of Human Rights does. It looks at it's not about what happens, the knock-on effects of one state policy on another state policy. It's about whether the domestic arrangements of the signatory states meets a reasonable interpretation of the convention. Then of course the issue arises, how minimal should that be? I mean, should it just be setting the procedural rights to have a rights in place, or does it extend to more substantive issues? And then you have transnational issues, which derive from us living in an interconnected world. And they seem to be more about the way in which in an interconnected world, the effects of, it deals with two things. One, that a state A can undercut the right to have a rights of state B through its policies.
Of the citizens of state B.
Yes, of the citizens of state B. So state A has the right to have rights, and state B has the right to have rights. But there are knock-on effects of one state on another. So that's one element of transnational. And then the other element of transnational is that you've got a number of citizens who travel between these states. They're either or who are stateless. But they're a small a relatively small group, relative to the people who live within the states. I mean, I know migration one cites large numbers, but for example, within the EU, one's talking about 2% of the population of the EU live in a member state different to their own. I mean, it's probably 50% in this room, but over the EU, but that's because this is a room of highly educated people. But outside this room, in the broader sphere, it's 2%. It's a large number, 12 million, but that's compared to 450 million or whatever. And worldwide, it's probably a similar sort of issue. So there's an additional point in granting these groups rights. If they're to have the right to have rights, you mustn't undercut the right to have rights of those who live within the units that they're moving to and from. So I think one's got, if you like, two different sorts of problem here. So first I just wanted to see if I'd got the characterization correct. If I had, then I'll ask questions about them. But that was, I just wanted to check that I'd understood this distinction between international and transnational and the way in which they impacted upon the right to have rights.
Not quite.
Okay.
I didn't do a good job then. By international, I was just assuming obligations at the level of state agents. I was using the term international precisely together with traditional state-centered international relations theory. By transnational, in many cases, I mean the kind of universal legal documents that are binding, the UDHR, International Covenant on Legal and Political Rights, International Covenant on Civil, but then there's an additional dimension.
You call that international on page 131.
Well, then maybe I've been sloppy. But I use Harold Coe's language there to talk about transnational, not only about these multiple documents, but also about the migration of public and private law.
Right.
And one additional characteristic would be that transnational would also involve interactions among non-state actors as well as individuals. So going back to the notion of the jus cosmopolitico.
But I mean,
yeah, that's just
one of the,
definitional.
I mean, just as but it is important because actually most international human rights documents are international in the sense that I've just
because states are signatories, but they are also at the same time. I mean, this is a contradiction in their heart. I'm sorry. This is a complete, the essence of the contradictory nature of the current practice. Right. Although states are their signatories, they are binding themselves to treat their own nationals and residents in accordance with certain norms. And you see, this is the process of self-binding. Not everyone binds. So what are the escape hatches for states? There are two. RUDs, reservations, understandings, and declarations, whereby, let's say you sign CEDAW. Even Saudi Arabia signed CEDAW, but it said, it took exception to this, it took exception to that, it took exception. So the state reserves itself, but once such a mechanism comes into effect, what also happens is that there is a process of monitoring and evaluation that goes on by UN agencies for whatever we think they may be worth. But more importantly is the mobilization of civil society groups and NGOs and individuals themselves within the countries as a result of the ratification or sometimes even just the signing process. Now, I'm relying here on empirical work done by people like Catherine Sicking, Activists Beyond Borders, Thomas Rippey's work. I mean, I'm not inventing these out of cloth. I mean, there is an actual process there that is something unique and that's interesting, that explains a little bit the vast proliferation of NGOs, INGOs in our world, for which there are very significant numbers. And that's where, when you had said earlier that there is no international civil society, I would say that there are interlockings of many transnational, civil societies and kinds of conversations. So this is, the world of a kind of new politics and activism that I had in mind. And I do apologize. I may have been sort of ambiguous, or
right.
In a couple of contexts.
No, I mean, it's just that, well, I mean, one could even talk about a distinction between the way in which these affect the domestic arrangements of these states, and then the way in which they affect the knock-on arrangements. Because as far as I know, I mean, what happens, in signing up to these states, I mean, even if there are activists beyond borders, what they're doing is they're linking up with activists within a state to change
Absolutely.
the practices
Absolutely.
of that state towards its own citizens. They're not dealing with the knock-on effects of that state on other citizens, strictly speaking. Because by and large, that's how these documents are understood. I mean, drafted, and that is what the role of the bodies that monitor them, like the UN Human Rights Committee or courts, is that they looked to what extent are these bodies treating their own citizens in accordance with the documents that they've signed. I mean, there is a black hole, I agree with you, in these documents. Arguably there is a black hole. I mean, this is the problem I was going to put to you, as about how they deal with the knock-on effects of their decisions upon other states, because these bodies don't tend to deal with the transnational, the international elements of rights discourse. But then, if you have groups which have the right to have rights, okay?
Right, this is the second part of your...
Shouldn't they, in a certain sense, isn't what you want is to have them directly engaging with each other? In other words, you want there to be an equal, inclusive and self-reflexive dialogue between them on that, rather than referring to this other body. I mean, the exceptions might be refugees who are stateless, but imagine that most of the groups are actually in states, but they're worried about, the people of Cyprus are worried about the implications of decisions being made in Russia and Germany or whatever. Well, there you might sort of say, well, we need to set up some kind of structure which enables those different states to deal with each other. Now, where I'm getting to is that, in a certain
You are
sense,
a democratic sovereigntist, that's all. You're in a Thomas Nagel, just the argument, Richard. Let's admit it. I know, I've heard it. It's a very difficult argument. I have great sympathy for it, but I'm going to come back. I'm sorry, I interrupted.
No, I mean, in a certain sense, well, it's more a kind of Rawlsian people's art. I mean, it's sort of saying that it's again about the relationship of the rights discourse to the right to have rights discourse.
Yes.
And so there's a role possibly for certain kinds of international institutions to ensure that the right to have rights is in existence. And then there's there's a different problem about the knock-on effects of one country and the rights effects of another, and then you've got those groups that are perhaps outside or traversing the system altogether, but then you need to kind of balance of their views and the integrity of those different elements as well. So there's three different kinds of problems, what I'm suggesting.
No, that's a helpful way of distinguishing among the various levels of problems, but I think you're creating more exclusions where I see kind of a fruitful back and forth and a kind of engagement. I mean, I would not dream of ever asserting that the simple declarations of rights creates the right to have rights for citizens. Otherwise, I would not be a democratic theorist, and I do consider myself a democratic theorist. It's just that I'm not a statist.
Right.
I leave open the question of the problem of territorial sovereignty as a problem. But I see more contention and fruitful interaction and learning where I sense sort of a certain skepticism on your part. Maybe you're not going as far as, Nagel as saying, well, really, basically, justice without the state that also guarantees and, inframes these. So you're not going there. But the whole purpose of, the whole blood of the kind of cosmopolitanism that I'm defending is, number one, let us try to understand this new legal political universe that we are inhabiting. Yes, states are still here, but they are really fundamentally in a new sovereignty regime, and this is changing. Let us try to understand the politics of this new sovereignty regime, and in second place, how can we think about possible transformative or oppositional moments in these in this new context, and indeed URIs generativity can only occur if individuals themselves within certain context claim certain rights for themselves, and that's always a process of democratic engagement. It cannot happen. It cannot happen otherwise. Even with respect to the claims of the stateless and migrants and refugees, and these are very separate categories of people, but it is always in many ways the citizens themselves that also raise the claims about the rights of others. Right? Very often, not anymore, these groups have no voice or little voice,
Sure.
and they are raised, they're raised from within, and so I guess I see, and we come back to this concept of the transnational. There are some social movements that are truly transnational in character. I think the environmental movement is. I think the women's movement is. I think the sexuality movement is. And I think even the movement for the rights of indigenous peoples. And what I mean by calling them transnational is that, of course, it is in the first place citizens within specific contexts but these movements learn from one another. They exchange strategies and tactics. They talk to one another. There is training, there is resources, and but they are active at all levels. I don't know if we would disagree about this. I don't quite think so, but you seem to sense that they're also somewhat more. Maybe the question of how do they relate to labor, and what are they? What is the relationship between labor and the unions? And I'm very heartened by the fact that within the United States that the AFL-CIO that used to be so reactionary, correct me Andy if I'm wrong, for so many years on migration question, for example, and this is not a theoretical issue, this is a political issue, has now come around to, demanding migration reform and, legalizing. So these are sometimes
That's
matters.
correct. Yeah.
That's right. These are matters of coalition. They are not matters of, in some ways, they are not matter at the level of political philosophy.
Yeah.
I mean, we know
Yeah.
sometimes that these movements have gone their own way, but there is no reason as to why, a new kind of coalitional activism, and it is so necessary, but so to be continued, I suppose.
Yeah. Okay, well, I think we've worked you very hard, but you've given us excellent value for money here, and I think we should all thank you very much for.
Well, thank
a
you.
great